Unit 2. Obtaining property. In this chapter we will learn about ways of acquiring property rights over real estate and taxes related to a transfer of property. The right to ownership of immovable property can be obtained in several ways. By legal transaction, which can be based on a sales or gift contract or contract of exchange. For real estate, a written form of contract is required. The right to ownership is transferred to the customer only after the new owner is registered in the land register, even if the contract has been concluded earlier. The contract only obliges the clients to each fulfill their obligations. By inheritance, the property right over the estate is acquired with the moment of the deceased's death. By a decision of a state body, the right to property is acquired by final court decision or final decision of an administrative body, unless otherwise provided by law. By constant use. In the case of a bona fide landowner, the latter acquires the property right on the property after the expiration of 10 years. Equally, the right to property is transferred to a specific part of the property, if it has been continuously held for 10 years and is in good faith. By dividing a common property or a joint ownership, in fact, the property right does not arise because it already existed, it only acquires the shares of other co-owners or joint owners. When transferring property rights to real estate, several taxes are payable. Real estate tax. In the case of real estate transactions where no value-added tax has been paid or charged, according to the Tax on Real Estate Sales Act, the transactions are subject to tax. Under this act, real estate transfer is also considered to be the replacement of real estate and certain other transactions of transfer of ownership of real estate. The seller is obliged to pay the tax and is obliged to submit a tax return for the tax on real estate sales with the tax authority within 15 days after the conclusion of the sales contract. After paying the tax authority confirms this on the original copy of the contract. Without a set and paid tax, it is not possible to authenticate the signatures on the contract with a notary and, consequently, to register the ownership of the property in the land register. The tax base is the selling price of the property, which must correspond to the market price. In case of inconsistency, the tax authority may initiate a measuring procedure, whereby the taxpayer has the right to challenge such a fixed price with the estimated individual market value of the property, but the taxpayer bears the cost of valuing the property. In certain cases, exemptions for this tax are also applicable, of which the most commonly used in practice are the following: the transfer of real estate in the division of property between spouses and extramarital partners at the time of termination or for the duration of the marriage or extramarital partnership or registered same-sex partnership, transfer of real estate at the time of the cancellation of contract on the transfer of real estate, transfer of real estate in the division of real estate between the shareholders or partners in the liquidation proceedings of the company, the transfer of real estate in the context of material status changes in accordance with the Companies Act, and the transfer of real estate as a substantive investment upon the establishment or recapitalization of a legal person. If it is a matter of acquiring a property right over a property through a gift or an inheritance, then this tax is not paid, the inheritance and gifts tax is paid. The tax rate is proportional and amounts to 2% of the tax base. Tax on inheritance and gifts. The person liable for inheritance and gift tax is a natural or legal person of private law who receives property on the basis of inheritance or donation, as well as a natural person who receives the property on the basis of a contract on lifelong support or on the basis of a gift contract for the case of death. As legal entities governed by private law, this law includes the following: associations, foundations, funds, institutions, private institutes and economic interest groups. The object of taxation is the property that a natural person receives from a natural or legal person as an inheritance or gift and is not considered to be income under the law governing income tax. The object of taxation under this Act is also property that a legal entity receives from a legal or natural person as a gift or an inheritance that is not considered as income under the law governing corporation tax. Real estate, movables and property and other property rights are considered property. The basis for inheritance and gift tax is the value of the inherited or of the property received as a gift at the time of the occurrence of a tax liability after deduction of the debts, costs and burdens that fall on the property from which this tax is paid. The amount of tax also depends on hereditary ranks and amounts from euros 500 to euros 107,600 and more. The tax on inheritance and gifts is not paid by an heir or owner of the first inheritance order. Heirs or owners of the first hereditary order are equalized with son-in-law, daughter-in-law, stepfather and heir or owner who lived with a deceased or owner in a registered same-sex partnership. A legal person governed by private law established on the basis of a law governing the pursuit of religious, philanthropic, charitable, health, social, educational, research or cultural activities or the pursuit of protection and rescue activities, but only if it is a gift or an inheritance intended to carry out such activities of a legal person. Value-added tax. Value-added tax is charged for any supply of goods or services by a taxable person, whereby a taxable person by definition is a person who independently carries out an economic activity. Real estate transactions, including finance lease, are considered to be the supply of goods. When selling real estate, VAT is charged for a new real estate or a new construction. For the supply of real estate in the territory of the Republic of Slovenia, the tax rates in force in the Republic of Slovenia apply. Income tax on capital gains. When the seller or the donor of a real estate is a natural person who acquired the property after the 1st of January 2002, in the case of the established profit from capital, in accordance with the provisions of the Personal Income Tax Act, income tax on capital gains in this transaction is also paid. It is taxed for the sale, donation and also the replacement of a property. However, the following transactions are not taxable: the transfer of the deceased person's inheritance to the heir or the transfer of immovable property within the framework of inheritance, insofar as it involves the transfer of immovable property under the contract of lifelong support or the gift contract for the case of death. In case of transfer of immovable property from the subject of expropriation, if a transfer of immovable property is carried out in the compulsory settlement of compulsory duties. In the case of a transfer of a property under a transfer on a lien basis. Income tax on capital gains is also not paid in the case of the sale of a dwelling or a house, with up to 2 dwellings, if the owner has a permanent residence in the real estate and has actually lived there for at least the last 3 years before the sale. The payment of personal income tax is also not required after the disposal of the property after 20 years of ownership and for the disposal of property acquired before the 1st of January 2002. The tax base on capital gains is the difference between the value of the property upon disposal and the value upon acquisition, from which a tax of 25% is levied. How to calculate this tax base? The real estate value on sale, donation or replacement is deducted from the real estate turnover tax, the cost of appraisal and 1% of the value of the property, which is recognized as a standardized cost. From the calculated value of the property at disposal, deduct the value of the property upon acquisition. The value of the property upon acquisition is calculated by adding to the initial purchase value of the property the value of investment in real estate and those maintenance costs that increase the useful value of the property. This does not include maintenance costs that allow for a normal residence in the property. The inheritance tax, gifts and potential real estate tax, appraisal costs in the maximum fixed amount, currently euros 188, and 1% of the standardized costs from the purchase value of the property are added. This gives us the value of the property upon acquisition. In the case of acquisition of a property by inheritance or donation, the value at the acquisition shall be taken into account as the value from which the inheritance tax and gifts were levied. The difference is taxed at 25% and is considered a definitive tax, which means that it is not counted against the annual income tax assessment base. The tax rate, set at 25%, is reduced every 5 years, and after 20 years of ownership of the property, this tax no longer exists. The taxpayer must submit the tax return within 15 days from the date of disposal of the capital at the tax office, and the tax authority issues the decision within 30 days from the date of filing the announcement. On the basis of all forecasts regarding capital gains, the tax authority issues a decision on the level of personal income tax on capital gains for the previous year and the current year. Income tax due to land use change. Since the entry into force of the Public Finance Balance Act, that is, from the 31st of May 2012, the tax liability for the payment of a tax on profits from the sale of land, which on disposal is considered as land for the construction of buildings, is established. It does not matter when the land was acquired. The taxpayer is the seller and the tax base is the difference between the value of the land at disposal, less the cost of disposal and the value of the land at acquisition, plus the acquisition costs. Only the costs recognized by the law governing income tax are taken into account. A tax on profits due to land use change is 25% if less than 1 year has passed until the sale since the change of purpose in land for the construction of buildings, and 15% if 1 to less than 3 years have passed, and 5% if 3 or up to 10 years have elapsed. Obtaining the property rights of foreigners in the real estate in the Republic of Slovenia. Foreigners may, on the basis of Article 68 of the Constitution of the Republic of Slovenia, acquire the property right to real property in the Republic of Slovenia under the conditions laid down by law or international treaty ratified by the National Assembly of the Republic of Slovenia. The laws enabling foreigners to acquire title to immovable property in the Republic of Slovenia are the following. Inheritance Act. The Inheritance Act in Article 6 stipulates that foreigners in the Republic of Slovenia regarding the right to inherit property, provided that the principle of reciprocity applies, have the same inheritance rights as citizens of the Republic of Slovenia. In this regard, the Reciprocity Recognition Act in Article 4 stipulates that reciprocity as a condition for the acquisition of a property right on immovable property by inheritance in the course of legitimate inheritance and to testamentary inheritance, when the heir is a foreigner who would be an heir even after a legitimate inheritance, is presumed until the evidence of the opposite. Where, however, in the succession of inheritance due to the inheritance of a property, reciprocity must be established, the court shall interrupt the succession proceedings. Reciprocity is established by the Ministry of Justice. Act on the condition for the acquisition of the right to property of natural and legal persons of the candidate countries of the European Union. The Act on the condition for the acquisition of the right to property of natural and legal persons of the candidate countries of the European Union states that natural and legal persons of the candidate in the candidate countries themselves may acquire title to immovable property if there is reciprocity. Reciprocity is established in accordance with the Reciprocity Recognition Act. The condition of material reciprocity is determined by the Ministry of Justice with a decision, namely for each property separately recorded in the land register. Reciprocity is given if a citizen of the Republic of Slovenia or a legal entity established in the Republic of Slovenia can acquire a property right on immovable property under the same or similar conditions under which foreigners can acquire a property right on immovable property in the Republic of Slovenia, and the fulfillment of which for a citizen of the Republic of Slovenia or a legal entity established in the Republic of Slovenia is not significantly more difficult than the fulfillment of conditions for foreigners in the legal order of the Republic of Slovenia, material reciprocity. On the basis of this Act, the Ministry is conducting a procedure for determining reciprocity if a property right on real estate in the Republic of Slovenia is to be acquired by a citizen or a legal person with head office in one of the following EU candidate countries: the Republic of Macedonia, Montenegro, the Republic of Serbia and the Republic of Albania. The list of all candidate countries for EU membership can be found on the web pages of the European Commission. Explanation regarding the status of Bosnia and Herzegovina. On the 1st of June 2015, the Stabilization and Association Agreement between the EU and Bosnia and Herzegovina entered into force, which represents one of the preliminary phases by which the potential candidate country is preparing to obtain the status of a candidate country for EU membership, and which, for the country in question, in the concrete case Bosnia and Herzegovina, does not mean acquiring the status of a candidate country for EU membership itself. The status of a candidate for EU membership is granted by the EU Council on the basis of a European Commission recommendation. Given that the Act on Conditions for the Acquisition of the Right to Property of Natural and Legal Persons of the Candidate Countries of the European Union binds legally guaranteed rights to the status of candidate country for EU membership, which Bosnia and Herzegovina has not yet acquired, for citizens and legal entities with its registered office in Bosnia and Herzegovina, it is still considered that they cannot acquire title to immovable property in the territory of the Republic of Slovenia. The only exception is the acquisition of ownership of immovable property on the basis of inheritance on condition of reciprocity. The law on the relations of the Republic of Slovenia with Slovenes outside its borders. The law on the relations of the Republic of Slovenia with Slovenes outside its borders provides that a person with the status of a Slovene without Slovenian citizenship shall have the right to acquire title to immovable property in the Republic of Slovenia under the same conditions as the citizens of the Republic of Slovenia. The status of a Slovene without citizenship of the Republic of Slovenia can be obtained by an individual which is of Slovenian origin, who is active in organizations of Slovenes outside the Republic of Slovenia or is actively connected with the Republic of Slovenia, who does not belong to societies, political parties and other organizations that oppose the international legal, constitutional and legal rights of Slovenes abroad or actively act against the constitutional system of the Republic of Slovenia, and who was not deprived of the citizenship of the Republic of Slovenia under the provisions of the law governing the citizenship of the Republic of Slovenia. B. Acquisition of property rights in real estate in the Republic of Slovenia on the basis of international agreements. Citizens of countries of the former Yugoslav Republic of SFRY and legal persons established in these countries. In cases where for all citizens of the former republics of the SFRY and legal entities established in these countries all conditions for the registration of title to immovable property in the land register were fulfilled before the 31st of December 1990, however, the entry was not realized or the procedure for registering in the land register was not initiated. In the procedures for registering property in the land register which were started now, in accordance with the agreement on succession issues applicable to all signatory states, all the countries of the former Yugoslavia, which entered into force on the 2nd of June 2004, it is not necessary to apply reciprocity decisions. However, the following condition must be met. At the beginning of the process of registering the property right in the land register, a foreign citizen must submit a document of proof. Most often it is a sales contract, which shows the valid binding and disposing legal transaction, with a valid land registry license under the then regulations. EU. Pursuant to Article 3 of the Constitution of the Republic of Slovenia and the Act ratifying the treaty between the EU member states and then candidates with which it acceded to the European Union, the treaties on which the European Union is founded have entered into force in the Republic of Slovenia. The Republic of Slovenia has not accepted any exceptions and transitional periods regarding the free movement of capital in the field of real estate. Therefore, from the day of the Republic of Slovenia's accession to the European Union, citizens of the member states of the European Union may acquire real estate on the territory of the Republic of Slovenia on the basis of all legal foundations, under the same conditions as the citizens of the Republic of Slovenia. EEA. Pursuant to Article 40 of the Agreement on the European Economic Area, Official Gazette of the Republic of Slovenia, NP, number 9/05, there are no restrictions on the movement of capital belonging to persons resident in the EC member states or the EFTA states, and no discrimination on grounds of nationality or the place of residence of those parties or the place of investment of that capital. Citizens and legal entities of the Republic of Iceland, the Principality of Liechtenstein and the Kingdom of Norway can therefore acquire real property in the territory of the Republic of Slovenia without any special restrictions applicable only to foreigners, and therefore they do not need an administrative decision on the establishment of reciprocity in order to obtain ownership of immovable property in the Republic of Slovenia. OECD. Acquisition of property rights for citizens and legal entities of OECD member countries over real estate in the territory of the Republic of Slovenia is possible on the basis of the law on ratification of the Convention on the Organization for Economic Cooperation and Development and Supplementary Protocols No. 1 and 2 of the Convention, Official Gazette of the Republic of Slovenia, NP, number 10/10, and the law on ratification of the Agreement on the Conditions for the Accession of the Republic of Slovenia to the Convention on the Organization for Economic Cooperation and Development, Official Gazette of the Republic of Slovenia, NP, number 10/10, from the date of the accession of the Republic of Slovenia to the Organization for Economic Cooperation and Development, OECD, Convention, that is, from the 21st of July 2010. OECD countries that are not EU member states are Australia, Canada, Iceland, Chile, Israel, Japan, Mexico, Norway, New Zealand, Switzerland, Turkey, South Korea and the USA. Citizens and legal entities of these countries may acquire a property right on immovable property in the territory of the Republic of Slovenia under the same conditions as nationals of EU member states, that is, under the same conditions as apply to citizens of the Republic of Slovenia. All OECD member states are listed in the following link. C. Other countries. Laws that would allow foreign nationals of other countries to acquire property rights in real estate in the Republic of Slovenia, with the exception of the aforementioned Succession Act, have not yet been adopted, and no international treaty has been ratified to allow citizens of other countries to do so. Considering that the legal basis for the acquisition of the property right of citizens of other countries in the Republic of Slovenia could also be an agreement of the European Union with other countries, which also refers to real estate transactions, we need to check with the Ministry of Economic Development and Technology for information on the possible existence of such a treaty in any specific case. Upon receipt of their response, we will conduct a procedure for establishing reciprocity as necessary. The same applies to legal entities established in these countries. How to implement the procedure for establishing reciprocity as a condition for obtaining the property right of foreigners to real estate in the Republic of Slovenia. Procedure for recognition of reciprocality as a condition for acquiring the right of foreigners to immovable property in the Republic of Slovenia. The procedure starts at the request of a foreigner who wants to acquire a property right on real estate in the Republic of Slovenia. A foreigner who does not live in the Republic of Slovenia is obliged to appoint a proxy in the Republic of Slovenia in accordance with the General Administrative Procedure Act, Official Gazette of the Republic of Slovenia, number 24/06 Official Consolidated Text, 105/06 US1, 126/07, 65/08, 8/10 and 82/13. Under Article 8 of ZUV, the application for the establishment of reciprocity is to be enclosed with personal data of a foreigner, in the form of a public document in the original or certified photocopies, passport or identity card. Proof of nationality, in the form of a public document in the original or certified photocopies, passport or other certificate. In the case of several nationalities of a foreigner, it is necessary to indicate where the foreigner has his permanent residence or where the foreigner had his last residence before obtaining a permanent residence permit in the Republic of Slovenia. A land registry statement for a property in a proceeding. The acquirer's legal interest, a document by which the client displays at least one of the conditions for obtaining a property right under the law or international agreement, for example a draft of a sales contract, a pre-contract, the contract itself. A statement of the purpose for which the property is acquired, for example, stay, secondary residence, pursuit of an activity. A real estate document issued by a competent branch of the Surveying and Mapping Authority of the Republic of Slovenia in accordance with the instructions for filling in a document with real estate data in the procedure for determining reciprocity, Official Gazette of the Republic of Slovenia, number 24/99, which should not be older than 45 days from the date of issue. When submitting an application, in accordance with the first paragraph of Article 5 of the Administrative Fees Act, Official Gazette of the Republic of Slovenia, number 106/10 Official Consolidated Text, hereinafter, ZUT, the administrative fee under tariff numbers 1 and 3 of the ZUT should be paid in the amount of €22.66. In accordance with the first paragraph of Article 8 of the ZUT, a taxpayer may pay the administrative fee. Payment method. Personally, at the lodging center at the headquarters of the Ministry. On payment, the client submits a confirmation to the Ministry, or, with a payment order, transfer to account. Reference SI. Common Ministry of Justice, Zupantsasiva 3, 1000 Ljubljana. On payment to the Ministry, the certificate is submitted to the Ministry. If upon receipt of an application, when such an obligation arises, the fee is not paid or is not paid in the prescribed amount, the Ministry shall send an invoice to the person paying a fee, ordering him to pay a fee in 15 days. On the basis of a complete application, the Ministry of Justice, for from the current record kept by it or on the basis of a request to the country of the foreigner, obtains information on how the acquisition of a property right located in the same or similar area for a citizen of the Republic of Slovenia is governed by the same or similar real estate and legal order of the country of which the foreigner is a citizen. The existence of reciprocity shall be decided by the Ministry within 90 days of receipt of a complete application by decision. After the expiration of 30 days, from the day the decision was served to the client or his authorized representative, and when the body receives a certificate from the administrative court that an administrative dispute has not been initiated, which means approximately another 10 days, the authority confirms the decision with a clause of res judicature or issues a certificate about the final decision. The decision thus provided is an authentic document on the basis of which the ownership right can be entered in the land register for a specific real estate. The foreigner must attach the final decision to the proposal for the registration of the property right of the foreigner on immovable property in the land register.